So hello everyone, and thank you for joining us live for this webinar. We are also recording the webinar and we'll be making it available afterwards. So welcome to those who are also watching the replay. Now, I know some of you have some experience of patenting and the processes involved, while others of you may be more new to it. So this webinar will be touching on some of the basics you need to know about patenting. And then we'll go on to discuss how it applies to the defence sector specifically. And we'll also highlight a number of client case studies to illustrate some of the strategies and important points, as well as demonstrating the value patents can bring to your business. So there'll be three of us speaking to you today, myself, Emily Teasdale, and my two colleagues, Tom Burt and Sarah Phillips. We have a lot of experience in advising businesses, both large and small, in this sector. Both in terms of protecting their own ideas and also navigating the intellectual property of others. So Tom has been in the patent profession for nearly 20 years after completing a computing PhD. He handles a variety of computing and electronic subject matter and is an expert in protecting software inventions around the world. As we will find out later, protecting software and computer implemented inventions has its complications, and we will hear from Tom later on this. Sarah joined us in 2015 and is well on her way to being fully qualified as a UK and European patent attorney. Her working life started at Fraser Nash, being involved with aerospace and nuclear projects. She has spent over a year working in-house on secondment to a large UK defence company, and she also advises SME clients in the defence industry. And then finally me. I've been in the profession for 17 years after studying aeronautical engineering. I enjoy working with clients of all sizes, mainly in the aerospace and defence sectors, and have significant experience of drafting, prosecuting and managing patent portfolios, as well as undertaking significant freedom to operate work. I also head up the Abel Imray Diversity and Inclusivity Group. So before we get started, just to let you know that you should feel free to post your questions as we go along in the Q&A box. Our colleague John is helping us out and we'll be keeping an eye on these for us to answer at the end. There will also be time for you to ask your questions at the end too. If you have any other questions, do feel free to email us. We will put our email addresses up at the end, or you can email ai@abelimray.com. Also, please do get in touch with us if you do wish to discuss anything here, in particular how your company can make the most of the patent system. We offer 30-minute complimentary discussions, so do feel free to contact us to set one of those up. Right, so here we go with some patent basics. So first of all, what is a patent? So patents protect ideas, for example, products, new methods of manufacture, etc. But they are just one form of IPR, intellectual property right. So each type of IPR protects different things. So you have trademarks that protect company branding and logos, the classic example of the Coca-Cola logo up here. Designs protect the way products look, for example, the design of the iPod or iPad. And you can have registered and also unregistered design rights. Copyright protects the expression of ideas like writing, music, art, films, etc. Now, copyright exists automatically. You don't need to apply for it. Finally, there's also confidential information, including know-how and trade secrets. So going back to patents specifically, a patent is a 20-year monopoly right that allows you to stop others from making, using, or selling your invention. Now, this monopoly is powerful as it does not require someone to actually copy the idea from you. So the third party could have come up with the idea totally independently, but still be prevented from using it by your patent. You must apply to get a patent. It's not automatic like copyright. And after you have applied, your application is examined and then hopefully proceeds to grant. And I'll talk a bit more about the examination process on the next slide. Importantly, once you have your granted patent, it could still be cancelled or declared unenforceable at any time. Now, classically, this happens when a potential infringer of the patent asks for a decision that the patent was wrongly granted. This can happen during opposition or revocation proceedings, i.e. proceedings to limit or revoke the patent. Can also happen during infringement litigation, i.e. litigation in which the patent is being asserted against somebody else. Patents are territorial. Now this means that a UK patent, for example, allows you to stop others using, selling and making your invention in the UK and also importing it into the UK. It does not protect you in other countries. So for each country where protection is required, you need a separate patent. Now, these patents are normally filed nationally, but there are a few regional organisations, for example, the European Patent Office, that make the process for obtaining protection in a few kind of countries easier. Generally, for UK clients, we first file a UK application, and then applications for any further territories are filed within 12 months of that UK filing date. So an important question is how you go about deciding which countries to cover, bearing in mind the need to achieve effective protection, but also making sure you get value for money. The main things to think about here are where your competitors and potential collaborators or their markets are based. Also where you might want to license the technology. This then needs to be balanced against the cost of obtaining patents and also the ease of obtaining patents in certain countries. It is also worth considering the enforceability in the different countries. So for example, China has traditionally been seen as a country where it is hard to enforce a patent, but I would say that this is not the case anymore. In some fields, protection in the US effectively works to block off other markets because competitors may not want to enter a product on the market if they cannot actually launch it in the US. If you are a small company and you have a technology that might take a long time to get to market, you may wish to concentrate on your home, for example, UK or European markets, although of course this might preclude that licensing potential in other countries. Another consideration is where your product or competitor product is likely to be manufactured. Again, you may be able to corner off a larger market by having patent protection in a few key manufacturing sites for your particular technology. Finally, on this point, I will leave you with the observation that even big companies in the aerospace and defence sectors do not often have large patent families covering a variety of different territories. For example, the key territories of Europe, US and China are often seen as a good default position, with further countries, for example, India, Russia, Japan and South Korea perhaps, depending on the importance of the technology. In all of these territorial considerations, it's worth noting that a patent has a 20-year lifespan and that both the commercial and patent situation can change in that time. And then the final point on this slide is that the patent applications are published, and this occurs after 18 months usually. And so at this point, all the information in your patent application becomes public. Now, this is the trade-off in obtaining that monopoly for 20 years. You need to disclose your idea in sufficient detail so that once your monopoly has run out, people are able to fully work your invention. So that's patents in a nutshell. So on the next slide, I'm going to be talking about what actually can be patented. Now, to be patented, an invention must have or be a few things. Firstly, it needs to be novel or new. This means the invention must not have been made public anywhere in the world at the time that the patent application is first filed. Now, importantly, this includes your own disclosures. So it's really, really important to file your patent application prior to any non-confidential discussions, for example. I would say this is a really, really key message. If you remember one thing from this talk, remember that. Don't talk about your ideas publicly outside of an NDA or something similar unless you've applied for a patent application or have decided you don't want to. This public disclosure also includes the disclosure of others. So if you're aware of competitors working on similar ideas to you, you may wish to think about filing your patent application promptly before they publish any of their information and developments. As well as being new, your invention must also involve an inventive step over what is already known. In other words, it must be unobvious to a skilled and knowledgeable but totally uncreative person in that particular subject or field. So important point here is this doesn't mean your idea has to be revolutionary. Instead, incremental or evolutionary improvements can be patented. In my experience, I find that engineers often think that something they have come up with is just obvious. But I would say if it is new and it has a commercial advantage, the chances are that you would be able to get valuable patent protection for it, and that this protection would put you ahead of your competitors. I would say think of this hurdle as needing an inventive step rather than an inventive leap. It's also worth bearing in mind here that even if ultimately you were unsuccessful in persuading a patent office that your idea was inventive, the fact that you've had a patent pending for a number of years may also be incredibly valuable to you in keeping your competitors off the market in that time. The third thing is your idea must be useful in industry. I'm not going to talk any more about this just because this is not normally a hurdle. And then the fourth thing is your idea must not be in an excluded category. Now, boundaries of what is patentable is the source of quite a lot of disputes and court cases, especially in the field of computer implemented inventions, which Tom will be discussing next. So these four issues, as well as a few others, such as clarity and what I mentioned earlier, sufficiently disclosing your idea, these issues are decided upon during examination of your patent application. Now, during examination, you can amend your application to limit the scope of your claims. For example, to limit the scope to something that is new. But importantly, you can only amend using features or combinations of features that are already included in your patent specification. Now, this is a really important issue and means that drafting of the patent specification at the beginning needs to bear in mind the level of detail that is likely to be required, and also the possible amendments that you might want to need and fall back on later. So once the patent examiner is happy, either because you've amended to a feature they consider to be novel and inventive, or because we've persuaded them to change their mind that a feature actually is novel and inventive, the application then proceeds to grant. So at this point, I'm going to hand over to Tom to talk about the specific issues to think about when protecting software and computer implemented inventions.
Great, thanks very much, Emily. So yes, I'm going to talk a bit about software and computer implemented inventions. So computer implemented inventions is a term that the European Patent Office use because they want to capture hardware, software, firmware, and everything like that. So the conventional way to protect software is using copyright. As Emily says, this protects written works, and that includes source code and compiled code, in fact, and it arises automatically, whereas you write the code, you don't need to do anything for it to come into being. There's some downsides in copyright. It only protects copying, as the name suggests, and it only covers code, not the underlying ideas. So if you've got some software with some functionality and a competitor comes along and writes their own code to implement that same functionality, the chances are you'll find it difficult or impossible to stop them doing that using copyright alone. And some things to watch out for: do you own the copyright? So if you've got a contractor writing your software code, a lot of people are surprised that the default position is you have a license rather than owning the copyright in the code. So that can be an issue if you want to use the software for something else, or if you want to adapt it yourself. So check your contracts. For copyright to transfer to you, it needs to be in writing somewhere in your contracts. And the last point is open source software. Now, open source software uses copyright in a slightly odd way. It says you can use our code without infringing our copyright, as long as if you adapt the code, others can use that adapted code under the same terms. So that means if your software product is based on an adaptation of some open source software, chances are you may find it impossible to stop people using your software using copyright or even patents as well. Now, it's slightly different if you're using some like open source modules, which a lot of people use because that's not an adaptation of the code. So don't think that using open source software is a complete no-no or a disaster if you have done. It's just something you may want to look into to check that you're happy with what you're doing. So now the main question, can you patent software? Yes, you definitely can. You hear a lot that you can't. That comes out of, I think, the European law, which is written in a slightly odd way that on face value suggests that you can't patent software or computer programs, as they call it. But yes, you can. So what are the actual requirements? In Europe, you need to have a technical invention. So it does something technical, solves a technical problem, that kind of thing. In the USA, it needs to be not abstract. It needs to be doing something more real world to stop it being a purely abstract thing. What do those mean? It ends up being a bit of an elephant test. You know one when you see one, but it's quite hard to describe one completely beforehand. It can end up being almost that the patent offices grant patents for the things that the patent offices grant patents for. Rather than spend hours having a philosophical thinking about whether or not your software is likely to be allowable or not, I'm very happy to have a 5-minute conversation with someone. Just tell me the rough sort of what your idea is, and I'll tell you whether it's the kind of thing which might be an issue or is something you ought to expect to be able to be patented. Moving on, I'm just going to go through a few examples of things that can and can't be patented. So on the can side, control software for a drone to make more stable flight, or generally control software for machines, processors, real-world devices. So it's the control of a real-world thing that gives it the technical, non-abstract character it requires and makes it patentable. Things at the level of computer architecture are also considered to be patentable. So if you're something that makes your computer operating system more efficient, more reliable, more secure, use less data, that kind of thing, all of those kinds of things are quite happily patentable. And things in the security field are also considered to be nice technical problems to solve. So a more secure way for devices to communicate, or for communication over the internet, or faster encryption, better encryption, all that kind of thing is happily patentable generally. On the side of things that can't be patented, so financial processes, you might, for example, come up with an incredibly complicated, difficult way of investing in the stock market, which is incredibly technical in one sense, but it's not technical in the way patents required. That's going to be considered to be a solution to a financial problem, not a technical problem. So it's going to be very difficult or probably impossible to protect that with a patent. However, doesn't mean things in the financial realm generally can't be protected by patents. So banking apps have a lot of security options. I've mentioned communication over the internet to make your communication between institutions secure. All that kind of thing is happily patentable. Pure calculation is another trickier area. In Europe, particularly, there's an exception for mathematical methods. So if you came up with an amazing new algorithm for working out the lengths of the sides of triangles, that's going to be very hard or impossible to protect on its own as a pure calculation method. However, if you implement that in a real world process, so for example, if you implemented it in a graphics card in order to render graphics more efficiently, better, more, all that kind of thing, that brings it into the real world and is then a technical thing, a non-abstract thing, and you should be able to protect that. Displays of information are another tricky area, again, because there's an exception in Europe, which is for presentations of information. But if you've got a clever process around the way you store the information that's displayed, or the way you extract it and combine it for display, that becomes a process for collecting, generating information of display, and not a pure display of information. So it brings you back into the real world. And again, that kind of thing you can protect. So they're just a few examples of things that you can and can't protect. You may have lots of other things. As I say, I'm extremely happy to have a 5-minute chat and just give you the idea, oh yeah, patent offices grant those all the time, or that's a tricky area we need to investigate. We can adapt your idea, something to bring it into the real world to make it technical. So that's it for me. I'm now going to pass back to Emily, who's going to talk about some of the benefits of patenting.
Thank you, Tom. So we've talked quite a bit about what you need in order to get a patent and how you go about it in the rough process, but why do you want to? So fundamentally, a patent protects your technology so that others cannot sell or make product or use processes that take advantage of your new ideas. In other words, they cannot just swoop in and take your technology for free. So this means quite a few things, actually. So firstly, you might be able to sell your product, for example, with the new and clever features that you've come up with, at a higher price, because competitors can't simply copy those features. It could mean that a customer is tied in to obtaining products of a certain specification from you, even if a contract with you perhaps has come to an end. I talked a bit earlier about making sure you filed your patent application prior to any non-confidential discussions. However, filing a patent application is a really good thing to do prior to those confidential discussions. For example, discussions with potential manufacturers, prototypers, or a customer. So whilst an NDA, a non-disclosure agreement, is a good thing to have in place, if it's breached, the remedies for then obtaining patent protection and protecting your ideas are very limited. It's also advisable to file a patent application prior to entering into any kind of joint venture. Filing that patent application puts that line in the sand as to what are your ideas, often called background IP, and what are the joint ideas that come out from that joint venture. This means that if that relationship goes sour later on, the party that you joined up with don't have access to your initial ideas, even if they have been privy to the later know-how and development ideas. Having a patent portfolio that disrupts the plans of others puts you in a strong bargaining position. For example, if you realise that you may wish to use someone else's technology, but you've got a patent that stops them doing something they want to do, you might be able to get a cross license with them with a much more favourable royalty rate, for example. You can license out your technology. You can even sell the patent itself, and this way you can get a revenue stream without even having to work the invention yourself. Having a patent application or a granted patent can attract investment. Furthermore, having filed the patent application prior to the investment discussions means that those ideas cannot be passed off as someone else's. And I've got an example of where this was really helpful later on. Finally, I just wanted to quickly mention the patent box tax regime. This provides for a lower corporation tax of 10% on profits that are related to a patented process or product. Now, for some clients, the savings that they get from patent box have easily justified the cost of patenting on their own. So now I'm going to move on to talk about a couple of case studies. I'm going to talk about two clients of mine. So the first client is IrvinGQ, formerly known as Airborne Systems. Now, this company has a long history and actually dates back to 1919. Their business is based around naval decoy systems, parachutes, and aerial delivery equipment. In particular, the patenting activity is focused on this aerial delivery technology, including the platforms that are used, for example, to airdrop a tank by parachute. And you can see one platform at the bottom left of this slide. Now, IrvinGQ came to me in 2015 because there had been a retirement at their previous patent attorney firm, and they felt that the new attorney in charge of their cases did not quite understand their technology. So since working with them, we've successfully obtained grant for their core hinge platform technology, so a platform that hinges. We've also drafted and are prosecuting a number of other patent families relating to some kind of subsequent ideas. So one example of this is the device at the top of the slide in the middle picture. Now, this is called a transfer safety link assembly. Now, what this does is it ensures that the main parachute that's used to lower the platform is not deployed until the load, i.e. the platform, has safely left the aircraft. Now, the patent coverage relates to having an ejectable connector, and it also relates to the mechanism that retains that connector. And it's only once the platform has left the aircraft does this mechanism then allow that connector or lug to be released, and therefore allow the main parachute to deploy. So in this photo, you can see the lever mechanism, which is to the right and slightly behind that blue strapping. And it looks like a backward C shape. So that lever is just starting to pivot away, and you'll see that underneath it there's a lug which is just about to be released. Another family protects the idea of the WISAD and LISAD, and that is water or land initiated sensing aerial disconnect. Now, what these devices do is they detect whether the platform has landed on land or water, and then automatically cause those parachutes to be disconnected. Now, the sensing devices have been cleverly designed so that they can be reused with a minimal amount of consumables. This means they are far more economical than alternative devices. Now, fingers crossed this works. We've got a quick video of the land version so you can see the automatic triggering in action. Now, on this video, you'll see, first of all, the platform descending with the parachutes attached. You'll then see the triggering device release the parachutes once it detects that the platform has landed. Thank you. So as you can see, you can now see that the platform with the tank on it has been delivered, and it can now be removed from the platform rigging much quicker as the parachutes have already been removed. It also means that that load has not been dragged across the ground by the parachutes, which otherwise it might have been. So you also know where to find it. Now, both of these ideas that I've talked about could be used with IrvinGQ's own platforms, or they could be sold separately for use with other platforms and delivery systems. Now, the patent protection that IrvinGQ have has helped them control their competition despite this, and they've been able to establish a sole source position with major governments. Now, this is very unlikely to have been possible without this patent protection in place. Okay, the second client I want to talk about is a client called Symbiosis. Now, in comparison to IrvinGQ, this company is very new, having been founded in 2017, but they are no less innovative. Not only do they create their own innovations, they're actually also able to offer bespoke innovation and testing solutions for others in the fields of material science and engineering. This includes materials testing and also bespoke nonlinear materials models. So Symbiosis first came to us to protect their ballistic armor known as Syntech. In particular, they realized that certain materials underwent phase changes when subjected to impacts, and that these phase changes could be used effectively to absorb those impacts. The first application for this technology is in bullet-resistant windows, and you can see a sample on this slide at the top left. The aim here is to produce a 50% reduction in thickness and weight. Symbiosis are also looking at incorporating the technology into cheap, light and formable vehicle armour and also body armour. You can see the body armour at the bottom left-hand side, a schematic view of it. An interesting point I want to talk about here is the timing of that first patent application that we filed. Symbiosis were keen to protect the concept of the phase change being used rather than being limited to certain materials. However, this broad range of coverage desired had to be balanced against the relatively early stage of development of the idea. It was also important that the patent application was filed prior to an equity funding round that was imminent, and this was important for 3 reasons. Firstly, having a patent application on file would help convey proof of innovation to the potential investors. Secondly, the application would have been seen as an asset that could have been sold and therefore increasing the value of Symbiosis to the investors. And finally, it was important to have filed the patent application prior to those discussions in order to preserve novelty in case the information was somehow leaked. In particular, here there was a concern that the phase change process could be worked out from the materials used and that the concept could be reverse engineered. Sorry, can we just go back a slide, please? Symbiosis were also aware of a technical paper that implied that others may be only slightly behind them in realising the potential for their findings. So we were really keen to get this patent application on file soon. A second and very different idea that Symbiosis have applied for patent protection for relates to a new approach for non-lethal stopping of tracked vehicles. This approach could replace the use of landmines for this purpose, for example. Now, this case has actually only recently been filed and so is not yet published. So I'm keeping the technical details under wraps for now. However, I wanted to talk about the timing of when we filed this. Again, this was filed prior to a discussion. Now, that discussion was part of a funding competition, potentially involving a large prime. Symbiosis were again concerned about potential leakage of confidential information, and so took that decision to file that patent application early before revealing any of that technical information as part of the funding process. I'm happy to report that Symbiosis idea has been successful in phase 2 of the DASA, that's Defence and Security Accelerator, called Stopping It in Its Tracks competition, and that further development of this idea is ongoing. I'm now going to pass you over to Sarah, and she'll be talking to you about avoiding the IP rights of others in relation to a case study of hers, as well as some specific issues that come up in the defence sector.
Okay, thanks, Emily. Hi, everyone. I'm going to run through our third case study, which is focused on Sights Ltd. Shield were one of the first companies that I got involved with when I joined Abel Imray. I've very much enjoyed working with them for about 5 years now. They design and make red dot sights for military use, but also for law enforcement and civilian use. They're a family business. They are experienced and passionate shooters themselves, and they make sights which are small and light and smash resistant if the firearm is dropped for some reason. So you can see their products in the photos. On the right hand side, we've got the Reflex mini sight compact version, which is made of aluminium and weighs just 16 grams. And then on the left hand side, we have the switchable interface sight, which is a slightly different design. It's fully enclosed and designed for the harshest military environments, and has some additional features in it as well, some additional reticules and brightness adjustment. So Shield's latest innovations are focused on improving the shooting experience for users, making the target quicker and easier to acquire, and removing obstructions from the field of view. Shield first came to us around 5 years ago when I got involved with them, because they were very surprised that they'd received out of the blue a letter from a US company asking them to cease and desist making 3 of their most popular products in the UK and also overseas, including in the US. So this was not a great situation for Shield. They knew the US company well. They'd worked with them in the past. They'd even sold some of their early sight designs to this company, who had then rebranded them and sold them under their own name. So whilst previously the relationship had been good, things had changed over time, and the original expertise and the innovations belonged to Shield, but they found themselves in a situation where the US company had filed and actually had granted patents which covered their own products. So we investigated this situation, and we found out that Shield had a brochure, so they had some evidence which predated the patent applications and showed something which was quite relevant to the subject matter of the patents, which arguably the US company would have known about and should have told the patent office about, but litigation was going to be very expensive, particularly in the US, and it just wasn't a realistic option. So ultimately we negotiated a license with the US company, and Shield thereafter had to either pay royalties on sales of its products, or they had to adapt their designs to work around the patents, and that's the situation that they are in presently. So this wasn't an ideal situation for Shield, but it was a pragmatic solution, and this really represented it. It was a moment of waking up to IP for Shield sights. And after that, they decided that they wanted to take steps to protect their market share and to be the first to file patents for their own innovations. And they have been steadily building up their own patent portfolio. So this case study highlights an interesting point of patent law. And we can move on to the next slide now, please. Thank you. The US company were able to assert their patents against Shield sights to stop Shield from doing something with its own products. However, the patents held by those US company did not allow the US company to actually make or sell their own products, and that's because they equally could be stopped by someone else's patents. So whilst patents give a legal right to prevent others from doing what falls within the scope of your claims, they do not give you any positive right to do anything at all with your products. And this is a commonly misunderstood point, but really, really important. So I'll just go over another example just to make sure that it's fully clear. So to give a completely non-military example, say that you'd come up with a clever invention and you have invented the car, and you want to file a patent application for it, and you do, and the Patent Office grants you a patent for it, and you then come to want to make and sell your car. So you try to do that, but then you find that actually someone else has already got a patent for the wheel, and you can't make and sell your car without a wheel. So you're faced with two options. You either try and agree a license, or you find some way to work around the patents, which might be quite difficult in this current example, or you just stop what you're doing completely. So that is, like I say, an important point, and there are two sides to patents. It's important to consider both patent filings and freedom to operate in the market. So searching and understanding what patent rights are held by your competitors, and therefore what you can and can't do. Okay, so that's freedom to operate. So now I'll run through a little bit about the process for classified inventions, so specifically relevant to this sector. The first thing to say is that you can file patents for inventions where the project is classified. The UK IPO is set up for this, and it has special procedures, which we'll come on to in a minute. But it's not the case that any vaguely military related subject matter will be handled via the special procedures. The UK IPO will look at this on a case-by-case basis in conjunction with the MOD. And it is the case that most inventions which are military related follow the usual process, which Emily has already described. So, and another point is that if it is desirable to keep your application out of the special handling arrangements, then we can work with you to draft the specification in a particular way to try and cover the invention, cover the core invention, but leave out any particularly sensitive information to the extent that that's possible. So that's something that we can discuss as well. Okay, on to the next slide then, please. So when we are going through this process, right at the beginning, we'll have an initial conversation with you where we discuss the invention, and at that point you would let us know whether there is a classification on the project. And then we will go through the drafting process, which many of you will be familiar with, so working with you as the inventors to prepare the specification for filing. Then, as part of this process, what we will need to do is consider the nationality of the inventors to check for possible conflicts. And what I mean by this is that in UK patent law, there is a requirement for inventions that have been devised by UK residents to be filed at the UK Patent Office first. However, if you've got an invention which has been jointly made by a UK national and a foreign national, then it may be the case that there are conflicting requirements in other territories that we need to consider. And those would need to be worked through on a case-by-case basis. But the default is that we file at the UK IPO. If the situation is more complicated, then we may need to investigate foreign filing licenses and looking into where would be the best place to file first. So that's an additional consideration that that is applicable when we're looking at these classified patents. So we will then file the application securely at the IPO, and the UK IPO, when it receives an application which has been filed through these secure channels, it will be carefully reviewed, and the UK IPO will make its own determination initially about whether or not they're going to raise a Section 22 order on the application. If they do raise a Section 22 order, then that means they then go into discussions with the MOD. If they don't, then the application is handled normally via the usual procedure. So this process of the UK IPO, I haven't quite moved on to that slide. Thank you. So this process of the UK IPO doing its initial review can take about 6 weeks. So it's advisable to wait 6 weeks before taking steps such as having conversations about the invention or filing overseas. It's important to wait 6 weeks and see whether an order has been raised or not. And as I said, if no order is raised, then it's handled in the usual way. And if an order is raised, then there'll then be a detailed review by the MOD. And at that stage, the Section 22 order will either be confirmed and the restrictions will be made clear, or there will be a revocation of the order, and the application will pass back to the normal channels. Okay, next slide, please. Thank you. So where a Section 22 order is raised on the application, the restrictions will typically include restrictions on publication of the information, but there would also be restrictions via the classification on the Official Secrets Act side of things as well. So, but this is purely from patent's perspective. There'll be restrictions on publication, communications, and possibly the territories that you can file in. So, when you want to come to discuss the invention with a partner organisation, for example, there would be 3 checks that you would need to do. You would need to consider the export controls provisions. You would need to check what you were allowed or not allowed to do via the classification in the Official Secrets Act, and then you would also need Patent Office approval, Patent Office permission to have those conversations, and that's something that can sometimes be overlooked. So it's something to note. Also, there will be restrictions perhaps on where you can file overseas. So where there's a Section 22 order in place, filing overseas will need to be via embassies and diplomatic channels. So everything will take longer, but it is possible to file overseas, and you just need to, well, we will be having conversations with you and the Patent Office to determine, in conjunction with the MOD, which territories will be possible for overseas filings. The application will be examined by the UK IPO in the usual way. It won't be published, and even when it grants, it won't be published as a granted patent. So yeah, so it's handled slightly differently, but the same criteria that Emily's already described apply. So it has to be novel, inventive, and the examination is fairly similar. One more thing to say before I finish on the Section 22 process. Section 22 status is reviewed regularly. It's reviewed initially at 9 months and then yearly after that. And if at any point it's found that the Section 22 order should no longer apply, then it will be revoked and the application will pass back into the normal channels. So to summarise on that, I just want to repeat that it's perfectly possible to file a patent application for something which has an official sensitive or a secret classification, and there's a slightly different procedure, but the Patent Office has well-established processes and is able to handle the applications, albeit in a slightly different way. So yes, that's all that I wanted to say, and I will now hand over to Emily for questions.
Thank you, Sarah. So yes, please do send in your questions using the Q&A box, which you should see at the bottom of your screen. We're now going to put our videos on, hoping that works, so you actually get to see us and we can have a bit more of an interactive chat. Of course, as I said before, if you want to chat to any of us in more detail, just drop us an email. We'd be very happy to offer a free 30-minute consultation. So do take up this opportunity to find out how we can help your company leverage the patent system to your advantage. So John, fire away with the questions.
Hey, okay, right, so I've unmuted myself, which is always helpful. So we've actually got a question from the webinar audience, probably directed perhaps to Sarah. It's, can Section 22 be applied to non-military applications for added security?
Oh, you're on mute, Sarah.
Thanks, Emily. Yes, so we don't make the determination. So the Patent Office will conduct a review, and they review the patent application whether or not it's been filed securely. But all patent applications which come through the secure filing channels will be reviewed. That doesn't mean that an order will necessarily be raised on every application. So if you filed securely for something completely unrelated in a completely different sector, then obviously the Patent Office wouldn't raise an order, but they will make the initial determination if they think that the subject matter is prejudicial to national security or to public safety. And if they consider that that's the case, then they will then discuss with the MOD, and if there's any doubt, then they will have a conversation with the MOD. And when we go through this process, if you have particular contacts in the MOD that you're working with on this project, then you can let us know, and we'll inform the Patent Office when we file the application, which very much speeds up the process. So when it goes through to the MOD, we can get to the right people more quickly. So hopefully that answers the question, but if not, then do follow up with me afterwards via email, and I'll happily talk to you more about it.
The next question was one in advance. It's what happens if, after you've filed your patent application, there are further developments of the idea?
Yes, I'll take this one. So it depends on the timing of those developments. So if your developments have happened within that first year, what we would normally do is update the specification, and then the specification that we then file in those other territories at the end of that first year would include that updated information. If the developments are after that time, it kind of depends on what those developments are. So if the new developments are actually sort of likely to get patent protection for themselves, so they're potentially novel and inventive of your original idea, I would suggest you might want to consider filing an updated application. So it'd be a totally different new family. Now, what this would mean is that, like I said, you'd need to be novel and inventive potentially over your earlier idea, but actually your protection will then last longer because your 20-year monopoly term will start later. The other thing to bear in mind is even if you these developments are not necessarily going to be, you're not going to be looking to protect them separately, you should still keep talking to us about what, the kind of development of your product and what actually you think you're going to bring to market. Because during the prosecution, we need to make sure that when we're amending the claims and amending the specification, we cover what you actually want to finally use.
Great, thank you. Sarah, just going back to you, there's a clarification question on your response.
Sure.
So the Section 22 is decided by the UK IPO, not by the applicant.
That's right. Yeah, that's right. So the UK IPO will make the initial determination upon filing, and they will raise, as a precautionary measure, they will raise the order, and they will then enter into discussions with the relevant people in the MOD to either confirm the order, in which case there will be restrictions on what you can and can't do, or the order will be revoked. So that's not linked to there being a classification on the project. They're separate things. It's not the case that they will only raise a Section 22 order if there is a classification, but they tend to go hand in hand. So if we're working on something secret, or if we're working on something official sensitive, then that would tend to go hand in hand with a Section 22 order. But the Patent Office makes its own determination. Yeah, so we can't choose to raise an order or ask for one. But if we are filing via the secure channels, then we're highlighting to the Patent Office that we think it's potentially relevant and that the subject matter may be prejudicial to national security. And you would tell us right at the beginning, we would be guided by you, so you would tell us that the project was classified, and then we would work in the right way with it.
Yeah, the upshot of this, I'll just add, is that if you wanted to file a patent application but you didn't want it to be published at the 18-month time period, there's not really much you can do about it. It does get published. It's only if it really is genuine prejudicial to national security that you get this order put on it.
Yeah.
Okay, thank you. The next question is, when reverse engineering, what IP concerns need to be considered and how can these be alleviated?
So in terms of reverse engineering the technology that you see other people putting out, if that's what the question is, you'd have to carefully consider whether they actually had protection for their ideas. So you can't just reverse engineer something. You need to check out whether you have that freedom to operate, whether they have that patent protection that would stop you. From sort of taking it on the reverse, if you wanted to release a product and you were aware that it could be reverse engineered, then you'd need to put patent application on file prior to launching that product.
Now,
yeah, sorry, go on, Tom. So I was going to say the reverse engineering effectively counts as that disclosure.
Yeah, and a very little thing comes up in software quite a lot, in that, so someone writes a bit of software and someone wants to write another bit of software that does the same thing. There is a thing that people do in that field, which is called clean room, where to try and put the necessary steps between it, you get one person looks at the software and all the functionality it has and writes that down as a specification, and then passes it to another developer who's not seen the software to write the code, and trying to put those steps between to ensure there's no copying. That comes in the copyright field to try and make sure you've got this separation between the two. It's talked about a lot. I'm not sure how much it actually happens, but it's talked about a lot. But yeah, in the patents field, yeah, I mean, a freedom to operate search, I think you'd want, wouldn't you? I suppose you could specifically, one thing that does help is rather than looking for any patent about that general topic, you could search by companies, which is quite a good way to narrow down. But with freedom to operate is often narrowing down from 2,000 patents to the ones that actually matter.
Thank you, panel. Tom, I think this next one might actually be for you. Don't you have to register copyright in the US?
Right, yeah, so me and Emily have both said that you don't have to register copyright and you don't have to do anything. There's an international convention called the Berne Convention that came in, I don't know, 1880 something, which everyone signed up to, all the countries, and says that you can't have any formalities for copyright to exist. But in the US, actually, if you want to litigate, if you want to get someone for copyright infringement, before you do that, you need to register your copyright there. So there is a process of registering copyright in the US, but it's not a requirement for the copyright to exist at all. It's a late stage thing for if you want to start litigation. I think there are actually advantages to registering there earlier in terms of getting damages and that kind of thing. But I'm not aware that as a matter of course that companies generally registered their software copyright, whereas artists and musicians generally do, I believe. So that's what it used. So it's not a requirement for your sort of copyright system, but it's a thing you can do. There's in a few other countries as well. And there's also systems, there's lots of companies. So there's in the UK, for example, where they will agree to allow you to register your copyright with them. Not clear what effect it has terribly, other than being sort of a proof that you had that information on that day. Actually, that's one thing I would say is if you did ever want to assert your copyright against someone, then one big thing you're going to have to show is that it is your copyright, the provenance, that it came from you. But for that, you more want kind of evidence. So in the software field, it would be sort of iterations of code and that kind of thing. So you could demonstrate that, look, we wrote this code, we didn't take it from someone else. And I guess a registration of a particular company registers thing might be useful in that regard, but it's not really, it's certainly not necessary.
Okay, thank you. So another question which relates to classified drafts. So for classified drafts, where the patent will never be in the public domain, why would you apply for one?
Well, there are a few reasons. The main one is licensing revenue. So whilst the patents aren't in the public domain, they can still strengthen your bargaining position and enable you to enter into negotiations, but these are all conducted in secret rather than the information being in the public domain. So a publicly available patent will act as a deterrent because people can see it's there. If you have a patent which is not in the public domain, then via secret discussions, you can make your partner organisations aware that you have that filing, and use it in your negotiations. And as I understand, that's how it works.
Great, thank you. This is the final question I've got so far. There's still a few minutes left for other questions. So panel, for the classified drafts where the patent will never be in the, sorry, that's a wrong, I've just read that one out. Is it possible to get patent protection overseas for defense related inventions?
Yes, I can take that one. Yes, it is, but you will need UK IPO permission if there's a Section 22 order in place. So you have to file first with the UK IPO, as I've described, and then you'll need their permission. So you'll need to, and they will discuss with the MOD and come up with countries where it's possible to file for that technology, and then we would go ahead in the usual way, but working to a shorter deadline and using courier services and filing via embassies and using the diplomatic channels. So slightly different process, but yes, you can. It's perfectly possible, and we would just need more discussions at the outset. Yeah, and for the UK IPO to be involved with the MOD in that process.
Great, thank you. Emily, back to you. That was the last of the questions I have.
Okay, so as there are no further questions, we'll call the webinar to a close. However, do feel free to connect with us. I've said you can contact us by email, you can find us on LinkedIn. Do let us know if you've had any other questions or you wish to talk about any of this in more detail. And we'll also be emailing out a copy of the recording, so do feel free to pass this recording to your colleagues or anyone else working with innovation in this sector. So it just leaves me to say, on behalf of all of us, thank you very much for joining us and for your questions. Have a good rest of the day and goodbye.